Good morning to all of you. Welcome to Legal Maths by Sai Babu Sankara. This video is for the final year students, that is legal ethics students. Today we are going to discuss the question paper 2019 part C. Right, question number 15. The Bar Council passed a rule vesting in it the power to remove the chairman and vice chairman also of the Bar Council through no confidence motion. Of course. So they have passed a rule stating that the Bar Council has got the authority to make a rule to pass a no confidence motion against the chairman or the vice chairman. But this rule was challenged as ultra vires, so it should be made ineffective. Ultra vires of the Advocates Act 1961. So the argument is that a smaller body like a State Bar Council cannot remove the chairman or vice chairman as related to Section 15. Section 15 of the Advocates Act deals with the election of the chairman. Right. So the main issue in this case is whether the Bar Council can make a rule for removing the chairman or the vice chairman. How? By passing a rule, by passing the so-called no confidence motion. Is it acceptable or not? Yes, definitely acceptable. So now, while discussing, you have to discuss all these facts. So Bar Council is an apex body. Bar Council of India is the totally controlling body. So Bar Council as an apex body, as the running the entire state advocates, definitely they can pass a resolution. Yes, because of the Cooperative Societies Act or because of Section 15. Section 15 deals with the election of the chairperson. Please remember, in General Clauses Act, please remember, whenever you get any doubt, you have to refer to the General Clause Act. Section 16 of the General Clause Act says, power to appointment includes power to suspend or dismiss also. Here it is clearly told. So please remember, the Bar Council can make a rule to suspend or to dismiss the chairman or the vice chairman by passing a resolution. Actually, this happened in the year 2012. Prior to that, there is a case also. 2012, the Bar Council President of Karnataka State, by name Magdum, I believe. Yes, he was removed through this no confidence motion. Why? Because when Chief Justice J.S. Kehar and others came, so while welcoming them, he could not speak in proper English. And secondly, his control of the Bar Council is totally absurd. So he didn't have any control over the same. Therefore, so even though there was a period for one more year, the Bar Council of Karnataka, they passed a resolution and removed him from the post of the chairman, and also the vice chairman was also gone. Of course, they did not attend the meeting on that particular day. I think it is in the year 2012. Now, as far as this case is concerned, there is a solid case law, that is Bar Council of Delhi versus Bar Council of India 1974. So here, the main issue is Bar Council of Delhi. So they wanted to, in 1969, Mr. Radhe Mohan Lal, he has been appointed as the chairman. Of course, during the year 1972, there were differences between this man and other members. They wanted to remove him. So therefore, on 22/9/1972, they passed a unanimous resolution against him. Then he disputed, chairman disputed. So how can you pass a resolution when Section 15 of the Advocates Act says that the tenure of the so-and-so Bar Council chairman is 3 years or till his successor comes. So when there is no proposal how to actually remove him, how can you remove him like that? He has approached the court, but court said, Section 16 of the General Clause Act, yes, definitely, even though there is no straight provision as stated by the Bar Council of India, please remember, the Bar Council of Delhi is entitled to remove him by passing a so-called resolution to remove him. Even associations, all these things, they do the same thing. So definitely it applies to Bar Council of India also. It is not a hurdle to Section 15 of the Advocates Act. If you write this much, it is sufficient. Then question number 16. So the Bar Council of India, they have framed pre-enrollment training and also apprenticeship rules. Reviving that a candidate seeking involvement or enrollment as an advocate, definitely he has to undergo 1 year training under a guide recognized by the State Bar Council. So this is otherwise called as pre-enrollment training. It was there previously, actually 3 years. A person who has completed 3 years of junior advocate, then only he is allowed to enroll himself as an advocate. Those, of course, now they are gone. Right? These rules were challenged as violative of Article 19, 1G of the Constitution. So it is ultra vires of the Advocates Act 1961. Now you have to decide. So the main issue is whether pre-enrollment training is necessary for the advocates or not. So unless he is trained, unless he has taken practical training for 1 year, can he be enrolled as an advocate? Court said, Supreme Court said, not necessary. No doubt, Bar Council of India, it has got powers under Section 49 of the Advocates Act to frame rules. This is pre-enrollment. When this Bar Council of India Act or Bar Council's role will come after your enrollment. You are guided by legal ethics or Bar Council method once you enroll yourself as an advocate. But before entering the service, please remember, so no such rules, definitely they will be ultra vires. So this is the right. There is a case law also. Indian Council of Legal Aid and Advice versus Bar Council of India 1995. No doubt, definitely the Bar Council can make rules regarding this case is relating to age and other things. But please remember, they should not be ultra vires to the Advocates Act. So when the Advocates Act will come into existence only after the enrollment. So before enrollment, the role of the Bar Council doesn't come before the enrollment. Therefore, not at all necessary. That's a good case law. V. Sudhir versus Bar Council of India. This is important. V. Sudhir versus Bar Council of India, 1997. Yes, here, same process, he wanted to get himself enrolled. But these people objected that Bar Council of India made a rule that you have to get internship or you have to work as a junior under senior lawyer under a guide authorized by the Bar Council, then only you are fit for enrollment. Then he said, it is all against to the principles of Article 14 or Article 19 of the Constitution of India. Therefore, he approached the Honorable Supreme Court. Supreme Court has clearly stated that, no doubt, pre-enrollment training is 100% better and necessary. At the same time, Bar Council of India admitted that 3 years LLB course is itself sufficient to become an advocate. And once he completes the course, definitely he will be enrolled as an advocate. Of course, he has to he has to get through the Bar Council examination, that is All India Bar examination. But he will be given a privilege till such time, till he completes the so-called examination within 2 years or so. Yes, he can continue to practice as an advocate. So that means he will be temporarily given sanad or identity card. So this is the practice. So here please remember, why this training? Bar Council of India on one side is admitting that a person who has completed 3 years of LLB, who has been trained rigorously, who has written the examination and also passing the All India Bar examination itself is sufficient to become a lawyer. Then what is the necessity for this training? 1 year practical training, 1 year job training, all these things, they are definitely ultra vires. But the court apex body said it is only prospective. That means these rules will apply. The training will not be from the future batches, but the people who has undergone training, yes, they will do. That is what is called doctrine of prospective overruling. Anyway, so the court has clearly stated that the rules framed by the Bar Council of India are against to the spirit of the Advocates Act and also to their own decision. Therefore, the advocate who has completed LLB need not undergo training for 1 year under a guide recognized by the State Bar Council as stipulated by the training rules of the Bar Council of India. So case has gone. But anyway, still now, even now our people are getting enrollment when once they complete the so-called LLB examination. So with these two questions, we are taking a break. In the next video, we'll discuss some other problem. Thank you very much.